I am not going to grant the motion to dismiss for want of speedy trial.
In evaluating the case to see if there was a possibility for a motion to suppress, I noticed that there was no body cam arrest videos on this case. And so the ADA at that time had to go to the San Antonio Police Department and request it. And it turns out that was never uploaded. So that was part of the delay.
The court is not inclined to exclude that or grant a dismissal for that one item.
If you recall, Judge, from the last setting, we were set for trial.
Mhm.
We were set for a motion to suppress evidence. About 20 minutes before that motion to suppress evidence, I was given some records pertaining directly to that motion to suppress evidence. And after that, obviously, I was forced into a position where I needed to request more time to review those records to see what that was about prior to the hearing.
Yes.
And you granted a continuance. I didn't want to have to ask for that, but I was forced to in order to effectively represent my client.
If I remember correctly, I stated that neither party will be charged a motion for continuance because if I remember correctly, and I like to think my mind is still a steel trap, although people have been trying to gaslight me of late. But what I remember is that the state had obtained some information, and it wasn't information that it just had sitting in a file somewhere. And so it didn't seem that it was neglect on the state's part or lack of diligence on the state's part. And I know you needed more time to review. And so the court said, I'm not charging anyone with a continuance.
The only small part about that I would disagree with, Judge, is that the San Antonio Police Department is part of the state, and they've had those records since for years. I'm not saying that this prosecutor had those records, but the San Antonio Police Department sat on those records until they were forced into this motion to suppress. And at the time, and the state had also filed their own motion for a continuance based on the unavailability of a witness.
Okay.
And now, and you admonished the parties, Judge, at the last setting, there was going to be no more continuances. This was going to be set for trial at the end of March.
Yes.
Since then, in the last 10 to 20 days before trial, we have received a tremendous amount of evidence, Judge, that's been uploaded. There's been 212 jail calls, 44 new videos, body cams, dash cams, 53 new PDF documents. And of those documents, one of them is a 571-page gunshot residue detailed lab report of the opinions set forth in the previous gunshot residue lab report. There was a Brady notice for the gunshot residue in the Bexar County Crime Lab. The letter was written from the DA's office in December of 2024. There was punishment evidence that was uploaded, all of cases that have been in the state's possession since before even this alleged offense date, as they are older files. There was a new firearms testing report that was requested by the state on the same date as the last hearing. So on February 20th, there's a submission saying that the state requested further firearms testing.
So I understand where this is going, but what are you going to be asking for?
I'm going to be asking for you to dismiss this case, Judge, based on a violation of my client's speedy trial rights. And if you let me just hash all that out.
Okay, sure. We'll go on the record.
Okay.
All right.
Oh, I thought we were.
No.
All right. I'm gonna have to say
No,
all that
I'm just
again.
trying to, yes, you're gonna have to say all of that again. All right. Court is calling 2000. Just one second. Excuse me. If you all on the back row, ask the deputy to move you down to the other end, please. All right, we're gonna go on the record. Court is calling 2023 CR 10004, State versus Tyler Ashwell. Can I have parties announced for the record?
Megan Galloway for the state.
Nathaniel Navy for Mr. Ashwell.
And are you Mr. Ashwell?
Yes, Your Honor.
All right, so we are here for a motion to suppress, but defense, there is something you wanted to address before the motion to suppress. Is that correct?
That's correct, Judge. I filed a motion to dismiss the indictment for violation of my client's Sixth Amendment right to a speedy trial.
And I'm sorry, just one moment. Let me make sure I have the motion to dismiss. All right, Yaya, Oh, I'm sorry, Jenna. I can't see around this screen. Yes. And state,
Yes, ma'am.
do you have a copy of his motion?
I do, thank you.
In this case, certain things were said that were off the record so that everything can be on the record. We were here previously where the state had more evidence to tender to defense counsel. The evidence that was tendered to defense counsel, the court is finding that it wasn't a lack of diligence on this prosecutor's part. So, and when I say prosecutor's part, I mean Miss Galloway. So once that evidence was received by Miss Galloway gave it to the defense. The court did not charge either party with a continuance because the court found that neither party was technically at fault or had unclean hands. So now we're here today for a motion to suppress, but the defense is asking the court to hear a motion to dismiss for failure to provide speedy trial and defendant's alternative motion to exclude evidence for violations of 3914 of the Code of Criminal Procedure. So far what I have said, does everyone agree that that is what happened previously?
Yes, but
I would just like to add a little bit of context that I did, like, as we did off the
Yes.
record, Judge. At that hearing, I received that evidence approximately 20 minutes prior to that hearing.
Mhm.
That was evidence that was in the San Antonio Police Department's possession. They are still an arm of the state. They are still the state of Texas. So even though Miss Galloway did not, and I'm not in any way insinuating that she did, intentionally withhold that or negligently withhold that, the effect was still that the state of Texas did not timely produce that
And
evidence.
the court understands that, but I just wanted the record to be clear that even though the court understands that there are certain agencies that are considered technically, as far as discovery is concerned, under the umbrella of the district attorney's office, I didn't want the record to reflect that Attorney Galloway in some way had evidence in her possession and just did not turn it over. I understand, counsel, what you're saying is that the police department or someone else had this evidence, not her having it in her possession. But I understand the rules, counsel.
I understand.
Yes. So the evidence that you're saying was turned over to you, if you want to place on the record
Yes.
how long the legal agencies had that evidence, you can place that on the record.
And so that evidence for that motion to suppress hearing on February 20th, that was in the San Antonio Police Department's possession since I believe the date of the offense, which is May 22nd, 2022, because it was real-time cell site location information, cell phone tracking data that was to Mr. Ashwell's cell phone. And so they requested that through his cell phone provider, and they had possession of that since the date of the offense, which at this point has been almost 3 years. And at the last setting, Judge, you gave me time to review that, and you admonished the parties that there would be no further continuances and that we would be proceeding the trial at the end of this month, March. However, in the month of March and in the last 10 to 20 days, I believe, I've received a tremendous amount of new discovery. And as I stated, that was 212 jail calls.
And I'm sorry, counsel, sorry to interrupt. So, so that I can take proper notes. Now, the items that were given to you on February 20th, what were those items?
So February 20th was just the real-time cell site location data, which related to the pings of Mr. Ashwell's cell phone and license plate reader information.
All right. And how long are you saying that the police department had that evidence?
Since the date of the offense, May 22nd, 2022.
Judge, and I do have a response to that, but do you want me to wait until?
No, we'll just take everything one step at a time. So we'll start with that. So the real-time cell site data, defense, you're saying that the police department or the agency had access to that, we'll say, since May 22nd, 2022.
Yes.
And then you received it from the state on February 20th,
25.
2025. All right, so let's start there. State, you want to address that one issue?
Yes, Judge. So regarding that cell site location data and the license plate information that was tendered to Mr. Navy at the last setting. It is my understanding that although a detective with SAPD did receive it on the date of the offense, which is May 22nd of 2022, SAPD was not in possession of it because that detective was no longer employed with SAPD. And so once I learned of the existence of this record, I actually had to call up to the chief's office, and they were reporting to me that they weren't going to be able to retrieve it because that officer was no longer with SAPD. However, I told them that they needed to get with their IT department to get into the officer's drive to try to obtain it, but it was not. I went to look at the case file, it was not anywhere within the case file. And so ultimately, after conferring with the chief's office, they were able to retrieve it from the ether somewhere and provide it to me. As soon as I learned of that, I called Mr. Navy personally and let him know that they should be sending it to me. And then when I received it, I immediately gave it to him.
So you're saying that that first item with the real-time cell site data, that an officer retired or left the occupation and nobody had access to his data?
So that's my understanding, Judge, that it was not properly preserved, and so nobody had because it was not within the case file. I had called over to each respective unit to see if they had a case file for the case and if it was retained that way, and it was not. And so ultimately, I ended up with the chief's IT office, and that's how they were able to get into something called the H tribe and retrieve it out of there.
Okay. All right. Any response?
Yes, Judge. When I was given those records, they initiated from an email that detective sent from a government email. So this is something that never left the possession of the state. While this detective may have retired, it was on his government email. I know when I've left a job and my old email is still there, then supervisors still get and sort through any emails that I may have received. Now, if there wasn't a proper procedure to make sure that was available, that's not my client's fault. But it was all of this originated and maintained in the possession of the state. It didn't go anywhere else.
Okay. And then your next issue.
Okay. The next issue, Judge, is that in the month of March 2025, I've received a vast amount of evidence that has been previously undisclosed to me.
All right. So let's do this because I say take the easiest part first.
Right.
So one of that is jail calls.
Yes.
All right. So let's talk about the jail calls. And I'm assuming the jail calls, are these alleged to be your client's jail calls?
They are.
All right. So let's talk about jail calls.
Okay. So there's 212 jail calls by my count. That number may be off by a couple if I miscounted, but more or less 212 jail calls. Those jail calls are from the day he was arrested, which was also May 22nd, 2022, until I believe somewhere in June. But my client didn't bond out until July 14th of 2022. So I don't even know if these are the complete list of jail calls because they end at a certain date in June. But still, it's a vast number of jail calls that I would need to sort through. The state's provided. That means I assume I don't know what they may intend to use off of there. If there's anything exculpatory, anything that's not good for my client, but I would need to review those.
All right. So state, with regards to the jail calls, because it appears based upon what defense counsel has stated, that his client was released from the jail in the year of 2022.
Yes, Judge. So the calls that were retained under this defendant's SID number were from his date of arrest, his date of release. That would be May 22nd of 2022 to July 13th, 2022. And these calls had not been pulled by any other prosecutor, and they were uploaded to e-discovery on March 3rd, 2025.
All right, so what I can tell you all with regards to the jail calls, I understand that sometimes when someone's in custody, if they keep making calls on a daily basis, then you're going to receive some phone calls, well, jail calls that are given to you not immediately because they're continuing to make calls. But in this instance, what the court is going to do with regards to his jail calls is that's going to be excluded.
Well, Judge, right now I'm not asking for exclusion because, and I'm hesitant to do so, because there may be things that that corroborate the defense in those jail calls, Judge. And so it's basically, and the gist of my argument is the state has placed me in a position between a bad decision and a worse decision.
Well,
Right.
this is what I can tell you. With regards to your real-time, the cell site data location, the court is not inclined to exclude that or grant a dismissal for that one item.
But Judge, if you would let me, I guess, just
Yes.
finish the train of thought with the evidence and then argue for the motion
Sure.
to dismiss. I understand, we'll respect whatever the court's ruling is on that, but I do believe that we have some pretty compelling arguments to
All
make
right.
for you on that. If you'd let me do that
Yes.
rather than
Sure.
I guess piecemeal each piece of evidence. And so, okay, so we did the jail calls and then also 44 dash cam and or body cam videos. And obviously, I have not had time in the month of March of this year, from that time to trial to review all those.
And when were those given to you?
Those were given to me sometime, all of this evidence was given sometime between 10 and 20 days prior to trial, which is tomorrow.
Okay. All right, you continue.
Okay, and then 53 new PDF documents. And of those, I've identified that those include a 571-page gunshot residue report, punishment evidence of at least 4 cases that are older than this case itself. So 4 cases that the state has had in its possession since before May 22nd of 2022. Gunshot residue Brady notice that the DA's office has had because their letter is dated in December of 2024. New firearms testing that was requested by the state on the date of the last suppression hearing. So they requested firearms retesting on February 20th of 2025. And then a new firearms report was issued in March of 2025. So probably just a few weeks later. And so I have a new firearms report. Also have new cell site location reports, not real-time cell site location, but historical cell site location. And then case overview reports pertaining to this case. So those 2 items, those reports are dated 2022. Officers wrote those in 22, and those have not been available to me until this time. I submitted my request for discovery and was very thorough in all the different types of evidence that I was included in. All these are covered by that motion, as well as punishment evidence, which I requested on that date on June 6th of 2022. So that's over 1,000 days ago. I've requested all of this evidence, and much of it has been in the state's possession for years. Now, whether it's one ADA who didn't look at it or another one, that doesn't matter to my client. The effect is we were ready to go to trial on the evidence that we had at the last setting, and then it was reset. We got ready again to go to trial on the evidence we had for this setting, and then it turns out that there's a whole swath of new evidence. And I will tell you, Judge, that one thing I appreciate about this court is we have a lot of discovery compliance dates at first, and you make sure that all the discovery has been complete. And then once you ensure that that's been done, then you set it for a plea deadline setting. And then after that, you give so after the client's had some time to determine whether he wants to accept a plea or reject a plea, then it proceeds to jury trial. I should be spending this time before the jury trial, preparing for the jury trial, not reviewing new evidence. And so it's undeniable at this point that Mr. Ashwell has made decisions on first-degree felonies, of which, if he goes to trial and loses, could potentially be spending the rest of his life in prison. He has made decisions now without knowing all the evidence that the state was going to use against him. And so at this point, Judge, there has been a violation of his speedy trial right because the prejudice to him has been so great. He's been on ankle monitor since he bonded out, which was July 14th of 2022. So he's been on ankle monitor for about 2 years and 7 months. Varying degrees of full house arrest. I believe most of the first year was just completely full house arrest. Then after that, partial house arrest after he had established a good rapport with the court that there weren't any violations. He was allowed allowances to pick up and drop off his kids, obtain work, but he's missed many opportunities for employment. He hasn't been able to plan for the future with this hanging over his head. He has 2 small children that he doesn't know if, based on what happens, he can't make plans for the future, as I stated. And so the anxiety has been extreme. He's not been able to review all of these new reports before this trial, for which he was, we were going to be ready until we received new evidence. Every time that he meets with me, he has to request from his GPS officer to, if he can come have an attorney visit, and that's not always able to be done quickly. So he plans ahead on that. We have not had time to go sit through and go through this evidence, Judge. And so if I could now call my client as a witness, just to put on some testimony.
All right. Do you not want the state to address what you have stated so far?
It just depends on what order you'd like to structure the hearing then, Judge.
All right, state, do you want to address the issues?
Judge, so I'm gonna go a little out of order, but regarding the new firearms report and defense counsel's motion, he states that the state never informed the defense that we were going to retest the firearm. That's a falsehood. I represented that to the court while Mr. Navy was standing here and his client was, that at the last setting, the firearms person, the person that did the initial firearms testing was no longer employed with Bexar County and that he wouldn't be available for trial until sometime in mid-April. And so I informed the court at that time that I had submitted the firearm for retesting. That way the witness would be available. And at that time, I informed the court that it would take about a minimum of 2 weeks to receive the report back. And so that's why the court gave us a 30-day reset. Regarding the 571-page detailed lab report, that's the lab discovery litigation packet. It can be turned over until they finish the firearms retesting. So that's the reason for the delay on that. Regarding the punishment evidence, I would disagree with Mr. Navy that he hasn't seen any of it because he actually represented the defendant on 2 of those cases. So he had the discovery for those. It was not uploaded in this case. However, the state's fine if the court chooses to exclude that evidence. And then the GSR Brady notice, I would argue doesn't really apply in this case. All it does is notify defense that there are questions that are asked when a GSR kit is taken. And that defense should know that if you watch his client's interview, because the questions that are asked were recorded, and so that has been turned over. And regarding the dash cam video or the 44 new videos, I realized that I believe that discovery was not complete on March the 10th. And so I took it upon myself to go over to headquarters and have a meeting with the detective because I believe that there was evidence that was missing. When I first met or sat down with the detective, he informed me that he believed that those 44 videos did not exist. I told him that I believed different and that I had an obligation to turn them over if they did exist. So we sat together, we went through SAP's database, and none of those videos were preserved under the case number. And so we had to go and search through each officer individually and find the relevant video. And so that's why it was not initially turned over. Yes, it was within their possession this entire time. It just was not retained properly in the case file under the case number. And so to comply with 3914 and Heath, I did take an affirmative action to go over there and find that evidence that I believe existed and to turn it over. So I went over there on March 10th and it was turned over to Mr. Navy on March 11th.
All right. And then you wanted to call your client?
No, if I could actually respond to that, Judge.
Sure.
I don't recall Ms. Galloway saying that she was retesting the firearm. I know all of us here are the same people that were here. I don't recall that. I remember the reset reason being that that the individual who tested it would not be available, and that was the reason in the written motion. If she did say that, obviously I apologize, but I don't recall that being said at all. And if anybody else here did, then if do you recall that, Judge? I don't remember that being said.
I do.
You do?
But here's the thing. This is what I want to stress to both parties. You all both are officers of the court. The court has never had any reason to doubt your candor and honesty with the court. So I do understand, as a former defense counsel, sometimes there are a lot of cases that you have, but the court does remember Attorney Calloway stating that it was
Okay.
going to be retested
Okay.
because the person would not be available.
Well, then on that issue, I do stand corrected.
Okay.
And then, however,
But I do understand the
Right.
other points that
this
that
is
you're
very
bringing up.
troubling with the other points with the San Antonio Police Department. And even if Ms. Galloway is making an effort to go inquire about evidence and retrieve it, we need to take a broad look of the length of the case. There's been multiple prosecutors that have had a hand in this case, and it doesn't matter. We don't judge it from who's the latest prosecutor on the case. We judge it as a whole. And this is still evidence that's coming in 1,000 days after I've requested it.
Mhm.
And so this is not the first time this has happened either. We've had many discovery compliance dates on this case.
Yes.
So there's been many opportunities for the state, no matter which prosecutor it's been, to get me the full discovery on this case. And here we are nearly 3 years later, and I'm getting more. I can't be confident that I have everything there is on this case just because of the pattern that's gone on, Judge. One of those discovery compliance settings was because in evaluating the case to see if there was a possibility for a motion to suppress, I noticed that there was no body cam arrest videos on this case. And so the ADA at that time had to go to the San Antonio Police Department and request it. And it turns out that was never uploaded. So that was part of the delay. And that was 30 to 40 something videos, Judge. And then obviously at the last setting, the San Antonio Police Department had not turned over everything. And then now at this setting, the San Antonio Police Department hasn't turned over everything. So where does it end, Judge? This has become a pattern on this case. And at this point, and I don't know if you want to address it bit by bit, I still have arguments to make.
Oh, no. I'll hear your arguments. Do you want to call your client?
I do, Judge. Okay.
All right. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Tyler Ashwell.
All right. Defense, you may proceed.
Thank you, Judge. Tyler, you were arrested on this case for this alleged offense on May 22nd of 2022. Is that correct?
Yes, I was.
Okay. And were you able to bond out immediately?
No, I was not.
How much time did you spend in custody before you were able to bond out?
A little over 2 months.
Okay. And when you did bond out, what was your condition of bond?
Well, no firearms and full GPS house arrest.
Okay, full GPS house arrest.
I wasn't able to get work at employment at all whatsoever.
And so have you had an ankle monitor on you continuously since that date?
Yes, I have.
Okay. And you were on full house arrest for a significant period of time, correct?
Yes.
You were not able to work?
No, I wasn't able to work.
Okay, you were stuck at home?
Yes.
Okay, you were unable to pick up and drop off your kids?
Yes, I've also been unable to find they've also did not renew my lease because of this case as well.
Okay, so you lost your lease in your apartment
Yeah.
because,
The home that I kept my daughter in.
okay. And so because of that, you were forced to move in with others.
Yes.
Okay, who else? Who did you move in with?
I moved in with my parents.
Okay. And was your GPS altered at some point to include the ability to seek work?
Yes, it was.
Okay. However, can you describe the difficulties you faced in seeking stable employment?
Yes, I tried to obtain work multiple times at multiple different places. and got very far up until the point where the background check came or scheduling came, where they weren't able to work with my GPS officer and get me a schedule on time so I could send it to my GPS officer, or just flat outright didn't want me to work there because of the case.
Okay, and so you needed to submit a schedule of your work hours to your GPS officer.
Yes,
And some employers wanted you to have flexible hours, correct?
correct.
And because you were not able to have that, you lost out on certain job opportunities.
Correct.
Correct. So you understand that you're charged with 2 first-degree felonies and a third-degree felony, correct?
Yes, I do.
You understand that if you go to trial and lose, the punishment range is up to life in prison.
Yes, I do.
Is it fair to say that the anxiety since you've been on bond and arrested for almost these 3 years has been extreme?
Yes, very much so.
Okay. Have you given up making any sort of long-term plans because you don't know?
Yes,
Yeah, and if you could just wait till I finish the question. Have you given up, given up making any long-term plans because you don't know what the outcome of this case is going to be?
yes, I have.
Okay. And we've met many times to review the evidence on this case and discuss strategy, correct?
Yes,
Okay. And every time we meet, you have to get approved by your pretrial officer.
yes,
And is it fair to say he's not always available?
yes,
Okay. So we've had to reschedule numerous times because you can't get approval from your GPS officer.
yes,
And we've prepared for trial multiple times this month, correct?
yes,
Okay. But have we had a chance to sit down and go over all of this new evidence that we've discussed here?
no, not whatsoever.
Okay. That's the witness.
All right, any questions?
Yes, okay, Mr. Ashwell, so while you've been under indictment and on ankle monitor, isn't it true that this court gave you permission to transport your daughter to the School of Science and Technology?
Yes,
And the court also amended the hours accordingly so that you'd be able to comply with that, right? And drop your daughter off?
yes,
Okay, and the court has even allowed you to appear at some hearings via Zoom, isn't that correct?
yes,
Okay, and so while you've been under indictment and on GPS monitor, you've become married, right?
yes,
Okay, and you also conceived a child with your wife, correct?
Objection, relevance.
All right, I'll hear the testimony. That'll be overruled.
You can answer the question.
yes,
Okay, and the court gave you permission to attend the birth of your child and stay in the hospital with your wife until she was released, correct?
yes,
And the court gave you permission to spend Thanksgiving with your sister-in-law, isn't that correct?
yes.
Okay. And so when you say that you were unable to work, what employment were you doing before you were arrested?
Judge, I'm going to object at this point.
Judge, it goes to the whether.
All
it
right,
goes to
the objection will be overruled.
What were you doing before you got arrested?
I was working as a gas station clerk
Okay. And how long have you been doing that?
for 2 years.
Okay. And that was 3 to 4 months at the Circle K, right? And
Yes,
then before that, you're working at Murphy's.
yes,
And so why are you not working at Circle K anymore?
because I'm currently working at Taco Cabana.
Okay, so you have a job currently.
Yes,
Okay. And when you say that you have to move in with your parents, I mean, you've lived with them before and done most of your adult life, isn't that correct?
yes,
And trying to obtain work, I know you at one point were trying to become employed with a car dealership, is that correct?
yes,
Okay, and so when you say you tried many times to obtain work, can you just give me a better idea of what that looked like?
that looked like multiple attempts reaching out on Indeed, also going to multiple interviews, not being able to get past that background check process
Okay.
each and every time.
About how many interviews was that?
I would say about at least 4 or 5.
Okay. But ultimately you were able to gain employment with Taco Cabana, and that's where you're
Yes.
working right now.
Yes,
And so you've provided your schedule from Taco Cabana to GPS, is that correct?
yes, my manager is willing to work with me.
Okay.
He knows the situation.
Thank you. No further question.
All right, any other questions?
Just briefly, Judge. But have you lost out on better paying opportunities?
Definitely so.
Okay. And so your lease was actually terminated because,
Yes, they told me they would no longer renew my lease at my apartment.
okay, nothing further, Judge.
All right, so I'm sorry, why are they not renewing your lease at your apartment?
And because of the case, they saw an article on the news of some
Okay.
sort, and they told me that they were not gonna renew my lease.
All right. All right, any other questions?
Not from the state.
No, Judge.
All right, so what will hear argument?
Okay.
And defense specifically, what are you requesting?
Judge, I'm requesting a dismissal of this indictment because my client's Sixth Amendment right to a speedy trial has been violated at this point. We have had many discovery compliance settings in this case in the nearly nearly 2 years that it's been pending in court. And a lot of that was me requesting discovery. One instance, the state realized that there wasn't the discovery available that I was requesting, so they had to seek it out. As I stated at the last setting, the state had to seek out discovery that the San Antonio Police Department hadn't turned over. And then again, for the third time, the San Antonio Police Department has not turned over all the evidence in this case when we're here for our second jury trial setting. And we've been ready for both of those settings on the evidence that we've had at the time. And so I can't feel confident at this point that there's not more evidence that the San Antonio Police Department has. If we're getting it piecemeal like this, that doesn't give me a lot of confidence that they've turned over everything. And this case is old, Judge. It's almost 3 years old. And so we, in March of 2025, are still getting evidence from June of 2022 and beyond. Yes, I represented Tyler on 2 of those cases, but I did not represent him on all those cases. Some of those cases are older than that. One of them is a juvenile case, and one of them was another case that I did not represent him on. All his adult cases were dismissed, Judge. And we've been put in a position where he has to get ready, build his nerves up. He's made very difficult decisions to reject the state's offers, and he's done so without knowing all of the evidence against him. That is extreme prejudice, Judge. He's making decisions that are going to affect the rest of his life when he doesn't know all the evidence against him because the state has not provided it. And so what would have happened if he did accept one of those plea offers? Would we have just never been provided the rest of this discovery to review? And so the prejudice is extreme, Judge. We haven't had time to review this. I don't want to ask for a continuance. We've been preparing for trial. We've been ready on this evidence, but there's no time to review all the rest of this evidence that we've discussed, Judge. It's just too much. And so, as I said, I'm hesitant to ask for exclusion of evidence because I don't know if there might be something that might be exculpatory or might support the defense in this and any of that, Judge. And so we've been put in a position where it's almost Russian roulette, or as I said earlier, forced to pick between a bad decision and a worse decision. Since he's ready and he wanted to go to trial, do we just say, okay, let's proceed forward and go to trial on possibly incomplete evidence, not knowing what might be before him? Or are we forced into a position where if we did that, it might affect his ability to have effective representation of counsel because I haven't had a chance to review all the evidence? Or are we now forced to delay yet again because the San Antonio Police Department hasn't provided all its evidence and violate his right to a speedy trial, cause further anxiety, cause further delay, cause further harm to his life? Judge, and then if I'll just briefly discuss the factors that you consider in Barker. One is the length of the delay. And U.S. v. Marion, Supreme Court case decided in 1971, that says that you can consider the length of the delay from the time of the arrest all the way to the present. And so a lot of this evidence is from 2022. We've been here he's had this case pending for almost 3 years. And the reason for the delay, a lot of this was for discovery, which in my opinion makes it even more egregious. There's every opportunity to disclose this, no matter which prosecutor it was. Previous prosecutors could have done that due diligence and tried to seek out all the evidence on the case when the time was appropriate. The time was appropriate when we were having discovery compliance settings. The time is not appropriate when we're set for trial. We should be preparing for trial, not reviewing new evidence. His assertion of the right. So he rejected the state's offer in November of 2024 and decided to proceed to trial. We acknowledge that we have not formally filed an assertion of that right, but that is not an automatic waiver according to Barker. It's just one of the factors that the court considers in its balancing test to decide if his right to a speedy trial has been violated. Barker states that the primary burden to ensure cases are brought to trial is on the state. And so if the state had done the state's job and provided us all the discovery during the discovery compliance settings, there wouldn't be a due process and a speedy trial violation in this case. And Barker also states courts should indulge every reasonable presumption against the waiver of right to speedy trial, and they should not presume acquiescence in the loss of those rights. I would argue we have not acquiesced to that at all. In fact, every time it's set for trial, we got ready for trial and we were going to be ready for trial. We didn't want more time at the last setting. I would argue that however the court notated that, the end result was I was provided discovery at the last minute and I had to review it to effectively represent my client. The result is that delay was on the state. And so Barker also states that the right to a speedy trial is a fundamental right. And so the burden is on the state to prove that he abandoned that right or relinquished that right. The state has not proven that to you today. Barker also said we reject a rule that a defendant who fails to demand a speedy trial forever waives his right. The better rule is simply that it is one factor to be considered into the inquiry. And so we've never filed a motion for continuance on the trial in this case.
All right, and what I can tell parties is, in this court, Mr. Ashwell, we're in trial every week. Sometimes we have many cases that are set for trial, and the case that goes is the oldest one, or maybe it's the person who's been in jail the longest, okay?
Yes, Your Honor.
All right, and I'm sorry, defense, you may continue.
Thank you, Judge. And then lastly, prejudice to the defendant, which Barker states is the most serious factor, and I believe that one is the one that weighs most heavily in our favor. That's because I don't think there's any contention that the Michael Morton Act has been violated in this case. All of that evidence that's been given to me that's existed since 2022, there's no way that the court can consider that evidence has been given to me as soon as practicable. It doesn't matter if there's a new prosecutor on the case that just decides we look at the whole picture, Judge. Giving me evidence 1,000 days after I've requested it is not as soon as practicable. As I stated, he's made plea decisions with incomplete evidence. And then we haven't had time to review all of the evidence. We should be finishing up our pretrial preparation, not spending time arguing this motion and trying to review new evidence. And as Mr. Ashwell testified, all the losses of employment, his apartment, he's been on GPS, his freedom's been restricted in one way or another for almost the last 3 years, whether it was in custody or on ankle monitor. And I believe the only just result in this case, Judge, because it puts us in a position where we don't want to have to ask for a continuance, and we don't want to. And we don't want to ask to exclude the evidence at this point because we want to be able to review it and see what's in it before we ask for that. And the only just outcome, Judge, because the state has put him in a position where the Michael Morton Act has been violated and his right to a speedy trial has been violated. And so the only just outcome is a dismissal due to the violation of his right to speedy trial.
All right, state.
Judge, so the constitutional right of a speedy trial does not equal a dismissal of the charges, and that is citing MTV State 253 Southwest 3rd 273. And so I do want to address the Barker factors because Mr. Navy is saying that And it is true, the defendant was arrested on May 22nd of 2022. Mr. Navy filed a notice of appearance, and I would ask the court to take judicial notice of the court's file regarding these dates. But Mr. Navy filed a motion of appearance on June 6th of 2022. A motion to substitute was then filed, removing Mr. Navy as lead counsel on December 20th of 2022. Mr. Navy is then hired and placed on the case again and on May 2nd of 2024. And so regarding the length of delay, I think the defendant hiring an attorney that late and it's after a year after he's been indicted, that would factor against the defendant and the length of delay. And so I think that the relevant time period that we would be looking at is beginning May 2nd of 2024 until now, which is less than a year. And so then regarding the defendant's assertion for a speedy trial, I mean, they have not asserted their right to speedy trial previously. And I would argue that Mr. Navy was not ready for trial in the previous settings. On June 5th of 2024, he filed a motion for inspection of physical evidence. On October 28th of 2024, he filed a motion to examine the scene. And so those are equaling that somebody that's not ready for trial and is still doing an investigation on case. And then we were here on February 20th of 2025, and that is when the parties made the court aware of the discovery that was turned over, and the state was ready to proceed at that time. So Mr. Navy can't have it both ways. He can't say, I don't want the evidence excluded, but I don't want to ask for a continuance. And so at that time, he was joining in on the request for more time to review that evidence. And so the defendant's failure to make a timely demand for a speedy trial indicates that he doesn't want one. And furthermore, filing for dismissal instead of asking for a speedy trial should weaken the speedy trial claim, because it shows that they don't actually have a desire to have a speedy trial, but just want the case dismissed, and not citing Cantu and Barker. Regarding prejudice to the defendant, I haven't heard any testimony that this is emotional distress more than, just what every criminal defendant has as they're awaiting trial. And so I don't believe that there was evidence that he's suffered any serious prejudice that's out of the ordinary. And so the court heard the testimony. He's been allowed to do many things while he was on ankle monitor. He has a job currently, and so we would ask that you deny the motion.
May I respond, Judge?
Yes.
I would just take issue with the point that was made that I was substituted out and then substituted back in. The state's responsibility on discovery is not to Nathaniel Navy. The state's responsibility is to Tyler Ashwell. And so it doesn't matter if at one point I wasn't the attorney on this case, Judge. The state has a duty to timely disclose this evidence to the defense, not any one attorney. And with regard to those settings that where I was asking to inspect the scene, asking to inspect physical evidence, these were very specific motions where there were very specific things that could not just be uploaded and I actually had to physically go do. But these were still discovery compliance settings where the state had more time. So going over all these discovery compliance settings, I think that just makes it more prejudicial, and that the state was given every opportunity and every chance over years to provide me complete discovery, and it still hasn't happened. And to say that another thing, which is to say we don't really want a jury trial. Well, I don't really know how to respond to that, because we rejected the offer and to this court said that we wanted a jury trial. But the question on a motion to dismiss for lack of speedy trial is not, the remedy is not to just say, okay, here's a trial. The question is whether a violation has occurred. And if a violation has occurred, the court must dismiss the case. And so the question you're deciding, Judge, is not, okay, well, when can I give you a speedy trial? It's, has a violation of his right to speedy trial been violated? And I would say it has, and that the only remedy is to dismiss the case at this point. And at this point, Judge, if I could turn it over to my co-counsel for a couple points.
Yes.
Sure.
William Salazar for Mr. Ashwell. Your Honor, respectfully, quoting Shelby State in general, delay approaching 1 year is sufficient to trigger a Barker inquiry. Here we have a delay of almost 3 years that should be enough to trigger that analysis. Upon triggering Barker.
And I'm sorry, and you're saying that as it relates to his not being in jury trial?
Him not having a jury trial that affords him also the rights of due process, which includes a right to a fair trial and the right to an adequate defense.
All right, because normally this court is in trial every single week. And the cases that tend to be first are usually people who are in custody or people who have cases that are older than, cases that are older than Mr. Ashball's case. So this court has been in trial on a weekly basis.
Certainly, and the defense is not positioning to the court that it's the court's trial docket that has caused this delay. The delay is resulting from getting evidence that was in the state's possession, admittedly by the state, that was not turned over until a month before trial, less than a month before trial. And in order for Mr. Ashwell to have an adequate, fair trial, he has to have the time to review that, and his counsel has to have the time to review that. He was deprived of that by getting relevant evidence disclosed to him only a few days before trial. Now in this defense here, Mr. Navy is in a position where he has the option to ask for exclusion of evidence that might be exculpatory or ask for a continuance. And either one of those deprives Mr. Ashwell of a right to a speedy trial, which Mr. Navy and Mr. Ashwell were in this position, not through any action of our own, but through the state's negligence and not handing over evidence that they were required to do under Heath and under Brady. And Heath has set out that the state is the state is the state, regardless if it's the DA or if it's the officers. And by triggering the Barker analysis, it's the burden shifts to the state to justify the reason for the delay. And once the court has gone into that process, it is required to weigh all four of the elements of Barker.
Okay, all right.
And if I could
No,
a
I'm sorry.
little further, I'm sorry.
I thought you had stopped. No problem.
The constitutional right to a speedy trial is fundamental, and the Criminal Court of Appeals has talked about three key interests. Now, the state has talked about Mr. Ashball's anxiety being not all that much. However, the court says that the third factor in restricting the possibility of impairment to the defense, the Supreme Court, the U.S. Supreme Court, as well as the Texas Criminal Court of Appeals, has conceded that the third interest is given the most weight due to its effect on the integrity of the criminal justice system as a whole. And that's quoting Barker v. Wingo. So here we have Mr. Ashwell, who has essentially been handed over evidence, a voluminous amount of evidence, just a few days before trial, and is expected to either make the decision to exclude said evidence or to proceed or continue. And neither one of those options allows, all of those options deprive Mr. Ashwell of his right to a speedy trial because he has not been afforded due process, and due process requires that he have all of the evidence as soon as practicable so that him and his counsel can form a valid defense of his case. And so now that the court has allowed the state to try to justify the delay, it's up to the court to decide if that delay is justified, if that is something they believe is justified, if an officer leaves his post and doesn't hand over evidence, and that's lost in the ether, as the state said, does Mr. Ashwell have to suffer? His right to a speedy trial is a constitutional right. And because of that, all four factors have to be weighed because a fundamental right is at stake. And if he goes forward without all the facts, without having had time to review, then he is deprived of his right to a fair trial. And he is deprived due process at that point.
Oh, is there anything else?
Your Honor, I would just say that my last thing would be that the more serious the deprivation, the more likely a defendant is to complain of the speedy trial. And that is quoted from Barker. And here we are, we haven't complained of a speedy trial up until this point because there has not been reason to complain of it until now. But it is so egregious that we have no choice but to assert that right, to remind the state of its obligation that's set out in Heath and Brady to comply with discovery. And essentially the state could, and not to say they deliberately did this, but potentially in the future, they could choose to disclose important evidence the eve of trial that could be exculpatory. And essentially the defense, if they don't have time to review it, is forced the decision to exclude.
Okay, so let me just explain to everybody. I'm just dealing with this specific case, not what may happen in the future. Just
Certainly,
what's happening here.
certainly. And that is exactly what's happened here. That is what we're facing here is the choice.
All right, so this is what the court is going to do. Number one, I am not going to grant the motion to dismiss for want of speedy trial. Number two, with regards to exclusion of evidence, if there is any exclusion of evidence based upon what the court heard, what will be excluded will be the jail calls and any punishment evidence. But the court is not excluding that at this point because defense, you're saying you don't know if you want it excluded or not. So defense, if after reviewing everything, you decide you want the jail calls excluded, then the jail calls will be excluded. After reviewing everything, if you decide that you want the punishment evidence that was, and when I say punishment evidence state, I mean that was recently turned over. If you decide that you want that excluded, then it will be excluded. And when I say punishment evidence, the court will need more knowledge to make a determination of what punishment evidence, if there was turned over and when it was turned over. Now, next thing, with regards to the GPS, is he on tracking with curfew or no?
No, I think he's on partial house arrest. Is that right, Tyler?
Yes.
All right. So I think I do not understand why pretrial services will not let him be at your office whenever you want him at your office. That is something that obviously I am extremely concerned about. I think attorneys should be allowed to meet with their clients whenever. As I said, you all are officers of the court. If you're saying that he is at your office or on the way to your office and you all want to have a meeting, if that meeting wants to be for 10 hours, you're an officer of the court. If you say the meeting was 10 hours, it was 10 hours. So I don't understand pretrial services not doing that. So with regards to GPS, what I'm going to do with GPS, he has, I think, an exclusion zone. Does he? Do you have an exclusion zone where there's a specific place you are not allowed?
No, not that I know of, Your Honor.
All right. So if there's an exclusion zone, the exclusion zone will continue. But what I will do is I will do tracking with a curfew, and that should be able to eliminate pretrial services. So you all step back and agree on a tracking with curfew and what time that will be. And with regards to the jury trial, that is tomorrow. Counsel, what I can tell you is we have other trials that are scheduled. What I want you to do, counsel, is estimate how long you think it will take you to go through whatever documents that have been given to you. And then both you and the state confer on a jury trial date that all parties can agree upon. And if there is more evidence that is turned over the defense, then the court will reconsider your motion.
Understood, Judge.
All right. Is there any?
I just want it to be said, I did comply with 3914 and I did seek out the evidence myself and took it upon myself. So, he's arguing regarding the SAPD, but I did my duty as the ABA on this case to
All
comply with 3914 and B.
All right. And so the record is clear. Again, both the state and the defense, I view you all as officers of the court. And no evidence that has been presented to the court where the court believes that Attorney Galloway did not follow through on her duties and diligently seek out evidence to give to defense. And I understand what the defense is saying about when you believe the evidence should have been given to you. But there are certain things that I understand that parties don't have any control over. I understand what the law is. I understand that the law considers the police department an arm of the state. And if the police department has it, the state constructively has it as well. So the record is closed. So if you all will confer on those two things, tracking curfew, and also when you anticipate you will be able to review what you need to review. And so it will be set on the jury trial date, which you all agree on, and a date before the actual jury trial date, so there can be a determination of whether or not you're seeking to exclude the jail clause and exclude the punishment evidence. And if there's an exclusion, you're determining that you want to exclude the punishment evidence, then we'll need to have a hearing in case the state wants to argue that maybe you received the punishment evidence beforehand. But with regards to the jail calls, if you want to exclude the jail calls, then we don't need to have a hearing on that because the court is saying the jail calls, that's something that you most definitely should have had.
And the only other question that I have, Judge, is what is the court's ruling as far as all of the other evidence that was turned over in March? Is it the same thing that applies to that?
Well,
It's
see, I
excluded until I review it?
I
or-
don't know with that. You're not asking for it to be excluded.
But-
You're not asking for a continuance. So with those, the only items that I am willing to exclude, because it seems that that is something that the state should have specifically been able to anticipate or have, is the jail calls. Because everybody knows the defendant is at the jail, they make phone calls. The punishment evidence, because the punishment evidence, the state should know what the punishment evidence is. If there are prior cases, then they should know that. So the other things that you mentioned, which is with the things that were in the ether, as people say, and IT had to be involved to get that, the court is not inclined to exclude that.
And Judge, my only other argument would be that that same logic should apply to the other evidence, including the firearm testing, the cell site location, and any of these other reports that were also provided, because many of these reports are from 2020.
Well, I will say with regards to the firearm testing, I do know that it was stated that that was going to be retested. And I understand that everybody gets involved in different things, but I do know that with regards to firearm testing, that was stated that that was going to be retested. I don't know if a motion was filed, but I know that that was stated.
And that report was turned over to defense on February 28th of 2025. So they've had it in advance trial.
All right, so if you all will step over there,
Okay.
Figure out the curfew with tracking, and then also when you all would request the jury trial.
And then I'm sorry to keep having questions, Judge, but so
Yes.
regarding all the videos too, all the different dash cam and body cam videos that obviously I haven't had time to go over.
Good job.
Is that also excluded?
At this point, I will agree to everything except the cell site data and the firearms because they've had that since the last setting. The court can exclude all of that. The state's ready to go to trial tomorrow.
Okay.
So
Well, I would request, because one of those is an animation of cell site data that I just recently
and
received,
it's
so I would
data
request
that
that.
he's received. It's just like a PowerPoint presentation. So
All right.
he's got the data.
So this is what we're going to do. The court is closing the record. Everybody has heard my ruling. It is not going to change. So if you all will confer on a jury trial date and also confer on tracking with curfew.
Judge, and then one last thing, because the motion to suppress and start today, did we still want to go forward because the witnesses have been there since?
Well, the question becomes whether or not defense wants to go forward on the motion to suppress. If the defense is not prepared to go forward on a motion to suppress based upon what they've received, then it's going to be reset.
I would request that it be reset to either like we did this time, Judge, either the day or the week before trial.
All right, so if y'all will confer on that and then come back to the court. Yes. On Ashwell, so with regards to curfew, let's start with that. So it's gonna be tracking curfew. No, we're fine. So what time?
We said 11 PM, Judge. That's because his Taco Cabana work gets out at 10 PM. Sometimes it's midnight, but we conceded with the middle ground and he'll work till 10 PM.
Okay, so, then we're going to do, and you all will need to write in order because of the way the system. Thank you. You know, at some point you could just print a page and write it on there, no more. Yes.
Is she coming back tomorrow, Judge? Because we need to know.
Okay, just give me 1 second, just 1 second. So on this case, tracking curfew, 11 PM. And when have you all agreed on a jury trial date?
Well, we had, but then I just remembered our investigator is moving.
Okay.
And so I'm trying to make sure that this date, moving out of the state, so trying to make sure that this date works for him.
All right, this is what we're gonna do. Your client can appear by Zoom. We're gonna recall this. How much time do you need for your investigator?
Well, I'm literally texting him right now.
Okay, then if you all will remain and let me know.
Okay.
All right, thank you.
Tyler Ashwell's case had been pending for nearly 3 years when Judge Boyd confronted the state over repeated discovery delays. Defense attorneys argued that critical evidence was still being turned over long after it should have been available, including evidence that had existed since 2022. The defense said they had repeatedly prepared for trial, only to discover additional evidence in reports appearing at the last minute. This created a difficult situation because Tyler was facing 2 first-degree felonies and a third-degree felony, with the possibility of spending the rest of his life in prison if convicted. The defense ultimately asked Judge Boyd to dismiss the indictment, arguing that Tyler's constitutional right to a speedy trial had been violated. Judge Boyd expressed serious concern, pointing out that evidence was still arriving nearly 3 years later and saying she could not be confident that everything had been disclosed. The hearing became a tense dispute over the state's handling of the case.